Hi, students. This is the second part of Unit 8. This part is pretrial identification. And remember, in order to charge a person, to convict them, to bring them to justice, they have to be identified as the person that is responsible for the crime. So the purpose of a pretrial identification is to verify that the police have apprehended the correct person and to generate evidence that can be used at trial. There are only three pretrial identification procedures. There's the photographic lineup, show up, and a live lineup. So I want to explain each of these, and then we'll get into the constitutional rules that apply to each one. So regarding a show up is generally it's done in the field. It's done during a detention. Remember, detention is based on reasonable suspicion that the person's involved in criminal activity. So the officers have to act expeditiously and use the least intrusive means to verify or eliminate the suspicion. For an example, if there's a robbery and the officers see a person fleeing matching the description, they can detain that person. And in order to verify that person, they may choose to do a show up. So they will have the witness or victim come to the scene of the detention, the stop, and take a look at that person to either verify that is the person, and if they verify that that's the person most likely will be arrested, or to eliminate that person. And if they're eliminated, of course, they would be free to go. So that's the show up. Close in time, close in proximity to the crime during a detention to eliminate or confirm that person was involved in the crime. A photographic lineup is different. So the procedure is an officer or detective who obtains the name of a likely suspect needs to identify if this person is the person who committed the crime. So they may put together a photographic lineup. Generally, a photographic lineup is uh, 6 pictures, 6 photographs. The photographs could be obtained from booking photos or from Department of Motor Vehicle records. The officer will assemble this photographic lineup. I used to use a manila folder and staple them in, number them 1 to 6. The suspect was in one of those positions. And then I would contact the victim or witness. I'd show them the photographic lineup to see if they could identify or even eliminate the person who was responsible for the particular crime. So you show them the lineup and you just wait to see how they respond. If they say that's him and they point to a picture, then what I would usually do is have them write on the back of that photograph, that's him. I would have them date it, initial it. Why? Because later at trial, they may have to testify and they may not remember. So in order to help their memory, they could look at the back of the photograph and remember that, yes, I did sign that. That's what I said. This is the date and this is the time. So that's a photographic lineup. And then a live lineup usually occurs after a person's charged, not all the time, but most of the time. And the request generally is made in court, and usually it's made by the defense attorney. So if the defense attorney has a question about his client being identified as a perpetrator, the defense attorney will request a live lineup or an Evans lineup. So the court case is continued. The prosecutor is in charge of arranging the lineup. The prosecutor will contact a jail. The jail will assist in assembling 6 people, including the defendant, into a live lineup. They will then contact the victim. They will contact any witnesses. And then the prosecutor, defense attorney, the defendant who's in the lineup, the victim, and witnesses will go. Generally, it's to the jail. There's a room there, and they will look at the lineup, and they will do that separately to see if they can identify the perpetrator. And of course, if they identify the perpetrator, that would be documented. It could be audio recorded, video recorded, You'd have a detective there. The detective would be with the prosecutor, would document it in a report. All these things would be documented in a police report. A photographic lineup is documented, the show up, and the live lineup. That's all documented. So those are the three procedures, and they all generate evidence. Each one is different, as you can see, and it fills a different role. So it depends on the case, depends on the circumstances that you are in as a police officer, that kind of dictate which particular identification procedure you will follow. There are constitutional requirements that come into play when you're talking about an identification. There's the Fourth Amendment. You can never get away from the Fourth Amendment. So an identification that is made that violates the Fourth Amendment, the general rule is that the identification would be suppressed. And there's an exception that allows for an in-court identification if the in-court identification is a product not of the photograph that was shown to the witness, but a product of that person's recollection at the time of the crime. So it's different. They're basing their identification based on their memory of the person at the time of the crime, not from the photograph. So that's the Fourth Amendment. The Fifth Amendment is the Due Process Clause. And the lineup procedure, the identification procedure, cannot be unduly suggestive. So the way that it's assembled and the way that it is shown to the victim or witnesses cannot be unduly suggestive. And I'll talk about that in just a moment. And then lastly, the other constitutional requirement that comes into play during the lineup is the Sixth Amendment right to counsel. So in some cases, they would have a right to have their attorney there, but not in each one. So we'll talk about those coming up. So let's talk about a photo lineup. So photo lineup, let's apply the Fourth Amendment to this photo lineup. So the identification has to be suppressed if an identification is made from a photograph that has been obtained in violation of the Fourth Amendment. So, for example, if it's a booking photograph and the booking photograph was based on an illegal detention or an arrest, then the identification should be suppressed. Now, I've done this a very, very long time. I'm up there in age. I've been involved in the criminal justice system for 45 years, 44 years, a very long time. I've never seen a photographic photo lineup challenge based on this Fourth Amendment. In any event, also remember that even if they want to suppress the photographic identification, the witness can still identify if they can testify that the identification is based on their memory of the person at the time of the crime. So that's the Fourth Amendment application to photo lineup. What about the Fifth Amendment in a photo lineup? It can't be unduly suggestive. So how does that come into play? Well, it comes into play two ways. One is the photographs themselves that are assembled to make the lineup cannot be unduly suggestive of the person who committed the crime. So if you have a suspect who's a old white guy like me, can you put in photographs of young Hispanic males? What would that photograph look like? Well, I'd stick out like a sore thumb, and that would be considered to be unduly suggestive. So the detective or officer that's assembling the photo lineup has to be very careful when they assemble the lineup and pick photographs that are similar. So they would generally pick, if it was me, they would pick 5 other white males, my age, my hair color, some facial hair, glasses. They would really have to pay attention because they don't want to be unduly suggestive. The photographs themselves have to be similar, but they don't have to be identical. The other thing is, after you make the lineup, the detective is going to mark that and have that placed into evidence because it could be challenged later on, and you want to be able to show the lineup that you used in that particular case. So that's the first way it could be unduly suggestive. The other way that the lineup could be unduly suggestive is the manner in which the officer shows the victim or witness. So if the officer is showing it, and the most egregious would be pointing out the person, to the victim or witness, that's unduly suggestive. But the officer has to be careful about what they say and how they react to the person when they're looking at the photograph, in order to make sure that they're not suggesting to the victim or witness who the person is. So when I showed photo lineups, and I have shown a lot of them, there was an admonition I used to give, and it was attached to the photographic lineup that I read to the victim or witness. And basically it said that you're about to view a photographic lineup. The person that was involved in the crime may or may not be among among these photographs. You're not obligated to make an identification. The purpose of showing these photos is to eliminate the innocent, as well as to identify the person that's responsible. And keep in mind that the photographs could be old, and the person could look different. And so you just read it to them, show it to them. I never said anything to them after I handed it to them, and I just waited to observe them and record what they said about it. So that's unduly suggestive. That's the Fifth, 14th Amendment that applies to the photo lineup. What about the Sixth Amendment right to counsel? We talked about right to counsel. When does right to counsel attach? Well, the person has to be charged. The person has to be present at the hearing, and important rights could be lost. So the Sixth Amendment is not going to apply to a photographic lineup, because generally it occurs, one, it's before charging. Secondly, the defendant's not present. So Sixth Amendment does not apply to a photographic lineup. What about a show up? Again, a show up is one that's made in the field during the detention. I described it already. What about the Fourth Amendment? The identification will be suppressed if it was made while the person was in illegal police custody. So generally a show up's going to be during a detention. It could be a consensual encounter, it could be an arrest. But what happens if the consensual encounter was not done properly? The court considers that to be a detention, and the officer does not have reasonable suspicion. It would be illegal. Or if the officer detains somebody, they need reasonable suspicion, but they don't have it, that would be illegal. It would be an arrest without probable cause, say. But the point is the identification will be suppressed. But again, there's that exception. So if the witness or victim can testify that the identification is based on their memory of the person at the time of the crime, not the show up, then the court would allow the testimony. What about Fifth or 14th applying to a show up? That's the due process clause. That's unduly suggestive. Well, honestly, a show up is the most suggestive out of all these identification procedures. Why? Because generally at a show up, you have an officer that has detained a person. The person may be in handcuffs. They might be sitting in your patrol car, might be sitting on the curb, but they're being detained. And there's an officer there. It's close in time, close in proximity to the crime generally. So it's very highly suggestive. In order to mitigate the suggestiveness of the procedure, the officer would also admonish the victim or witness. And again, the officer would say pretty much what I just indicated I said to a person that was looking at a photographic lineup. You would tell the person that, we're going to go have a look at a person who's been detained. Don't assume by the fact that the person has been detained that he's in handcuffs, he's with a police officer, that he's the person that committed the crime. You're not under an obligation to make an identification. The purpose of this identification procedure is to eliminate the innocent as well as to identify the persons responsible. And you would give them an admonition similar to that, and you would the person would be driven to the scene. They would look, and then you would record what they say. Now, again, you got to be careful about what you say and how you react to the during the viewing if you're the police officer, because you don't want to say or do anything that would be suggestive of that this is the person that was involved in a crime. And then what about Sixth Amendment right to counsel? Well, generally a show-up is done prior to charging, so Sixth Amendment right to counsel does not apply. The person is present and important rights could be lost, but because he hasn't been charged, the Sixth Amendment does not apply. Then the last one is a live lineup. I described that to you generally at the jail after the person's been charged. The prosecutor arranges it with the jail. The prosecutor and the detective go to the jail along with the defense attorney, victim, and witnesses, and then they take a view. They view these folks. So again, the Fourth Amendment is the same as the previous two. It'll be suppressed if the person was illegally in police custody. And again, there's that exception I've already talked about if the identification is based on the person's memory rather than the identification procedure, then the court would let it in. Again, the Fifth and 14th due process clause, the suggestiveness comes into play with a live lineup. So again, there's two aspects to this. The officer and prosecutor that are putting together the lineup have to be very careful, just like the photographic lineup, that the perpetrator does not stand out. It's not suggestive that he's the person that was involved in the crime. So again, if I was in the lineup, you'd generally be looking for people that are my age, hair color, glasses. They should all be dressed alike. If they're in the jail, they're going to be wearing jumpsuits, so you'd pick the same color. You have to be very careful when you put together the lineup itself. And then also the way you show it to the victim or witnesses, you got to be careful there that you don't say or do anything to suggest who the person is. Now, in a live lineup, the defense attorney's there. What is his role? His role there is as an observer. The defense attorney does not control the lineup. However, I will say this, if you're the officer and you're going to be smart about it, if you're putting together the lineup, then you might want to ask the defense attorney if he approves of the lineup. And the defense attorney makes a suggestion, say he doesn't like number 2 in the lineup, then you should probably switch out number 2. And you really would like to get the approval of the defense attorney. Why would you want to do that? Why do you want to work with the defense attorney if you're the prosecutor? Why? Because the defense attorney is there to make sure it's done correctly. If it's done incorrectly, the defense attorney will challenge it in court. However, if the defense attorney has approved it, he's not going to be able to challenge it in court, right? On the other hand, if you're a smart defense attorney, if the prosecutor asks you to approve the lineup, if you're the defense attorney, you should tell the prosecutor, I'm just here to observe. And then you would document the lineup, and if there's any issues with the lineup, then you can make a motion to suppress the identification in the court. So it depends on which side you're on. If you're the prosecutor, you want the defendant or the defense attorney to approve. If you're the defense attorney, you're going to leave it to the prosecutor to basically make a mistake and then bring that up in a motion in the trial court. Let's talk about right to counsel in the live lineup. Generally, as I indicated, it occurs after the person's been charged. That's meets one of the criteria for right to counsel. So the person's been charged, the person is present, they are in the lineup, and important rights can be lost. So yes, right to counsel is triggered at a post-charging pre-trial identification lineup. And so that's why you have the defense attorney present at the lineup. So that's important. to make sure that that is done. So those are the 3 identification procedures. There's 3, there's only 3. Each fulfills an important need for law enforcement depending on the circumstances of their case. The officers have to be thinking about the constitutional provisions that apply to those procedures and make sure that they are handling the procedure properly in a lawful manner to avoid, a motion to suppress in the court suppressing identification. So that is it for this video, and I'll be talking to you soon. I hope you're doing well and staying safe. Take care. Bye-bye.